road, an unknown male approached her, put a towel over her head, and forced her into the back seat of her car.
All I know, he was brutally murdered by you, and he basically died for nothing.
An intent to kill a person, an intent to break into a house.
In September 2018, Christopher Eric Pinkard committed a violent carjacking in Dearborn, Michigan. Disguised in a DTE Energy uniform, he approached two brothers outside a hookah bar on Warren Avenue, greeted them casually, then suddenly pulled a weapon, assaulted one of them, and stole their vehicle. The victims pursued him in another car until Pinkard crashed the stolen vehicle into a house in Detroit and fled on foot. Investigators quickly identified him after finding his ID in a nearby running car and confirming his identity through a passerby he had spoken to moments before the crime.
The officers came back asking, "You guys see a man wearing a DTE Energy shirt?" And I'm like, "Yeah, he just passed by." And I'm like, "He said hi." He's like, "Well, you just robbed your neighbors at Point." He left it running, came down, walked around the building, robbed their car, took off, and left this car on the side of the building.
How bizarre is that?
Officers knew who he was by finding his ID in the car.
He was arrested on September 4th, 2018, and appeared unremorseful in court, even laughing as he faced numerous felony charges. Pinkard was arraigned before Judge Mark Summers in the 19th District Court, facing charges including carjacking, armed robbery, and multiple weapons violations.
Mr. Pinkard is a suspect in a strangulation where shots were fired the day before this incident in the city of Dearborn, and also the day after the city of Detroit on an additional carjacking.
He was also charged as a four-time habitual offender. In March 2019, he entered a plea agreement and was sentenced to concurrent prison terms, 8 to 20 years for carjacking, 2 years for felony firearm possession, and 1 to 3 years for reckless endangerment, 15 years for third-degree criminal conduct related to an earlier offense. He is currently serving his sentence at Parnell Correctional Facility in Jackson, Michigan, with an earliest possible release date of March 27, 2029, and a latest discharge date of December 5, 2041. Arturo Flores, 56, a former computer teacher at St. John Birchman School, was convicted of multiple counts of indecency and inappropriate behavior involving students under his supervision. Testimonies during the trial revealed a troubling pattern of misconduct in which Flores allegedly approached students and engaged in physical interactions that were deemed inappropriate and invasive.
He would come back from behind and he would come over like this.
Witnesses stated he would make inappropriate comments while engaging in behavior that made others uncomfortable, crossing professional boundaries, and breaching the trust expected from an educator.
He would go over our chairs and over our bodies and hover over us. He would come from behind and then he would say, "Let me feel your heartbeat." And then he would go inside my shirt.
The case gained significant attention after 2 students came forward, leading to Flores' conviction on charges of indecency. Following the trial, additional allegations emerged from other students, detailing similar behaviors. These revelations painted a disturbing picture of repeated misconduct over time.
He's been a teacher, he's been a mentor, he's been a dad, he's not a monster.
If you give him probation today, you are giving the big stamp of approval on his conduct.
During sentencing, Flores' defense argued for probation, presenting him as a dedicated teacher, mentor, and family figure. However, the prosecution countered that his actions represented a severe breach of trust in a setting where students should feel safe.
I'm sentencing you, sir, to 20 years in the institution of division of criminal justice.
They knew what they wanted to do, they knew what they had to do, and they did the right thing. When you have people like the defendant in this case who take advantage of children while at school in that safety zone, I mean, we have to send a message to them. And I think the jury did a great job saying we will no longer tolerate behavior like this in our schools.
The jury unanimously rejected the plea for probation, sentencing Flores to 20 years in prison for each count, with the sentences to be served concurrently. The verdict was seen as a strong statement against tolerating misconduct within schools. Jennifer Fichter, a former English teacher at Lakeland's Central Florida Aerospace Academy, was convicted in 2015 for engaging in relationships with 3 male students. In November 2016, Fichter appealed for a reduced sentence. She learned that her request for a reduced sentence was denied.
Is your son alive? Is he alive? Is yours? Is he alive? Your daughter is. My daughter is not. You taking my life away. decision.
We had to make a decision.
Good.
I could
Well, I'm glad you
affect
can live with your
another person's
decision.
wife,
Okay?
and I did, because
Good.
your
I'm
daughter
glad. You
put
can
us
live
in
with
that
it.
predicament.
You can live with it.
Following the hearing, tensions flared between Victor's mother and the parents of one of the victims. A heated exchange unfolded, requiring other family members to intervene and separate the two sides. Victor's new attorney, Robert Norgard, argued for leniency, citing studies suggesting that women in similar situations often act out of emotional distress rather than predatory intent.
I've been doing this over 35 years, and if you try to compare case to case, you'll drive yourself crazy. It's apples and oranges.
The defense also referenced other well-known cases, such as Deborah LaFave, who received no prison time. However, the judge stood firm, emphasizing that such comparisons were not straightforward and that each case is unique.
Once a judge makes that initial decision, it's part of their nature not to second-guess themselves.
The judge upheld the original 22-year sentence, a decision that sparked intense emotions outside the courtroom. Victor, who expressed deep remorse during her original sentencing, likely did not anticipate the severity of the 22-year punishment. Erin Colleen Haste walked into Clark County Court surrounded by supportive friends and family, ready to confront the man who had caused her so much pain. Michael Sergio Bordolini, 51, whom she had met through a dating app, was convicted of raping her in 2021 inside a Vancouver home. The assault had left a lasting mark on Erin's life, but she was determined to share her story and seek justice.
One count of rape in the second degree.
In October 2023, a Clark County jury convicted 51-year-old Bordolini of second-degree rape, a Class A felony in Washington state.
That night, I wanted to move. I wanted to scream. I tried to move, but his body weight was on top of me, and I wasn't able to do anything. I don't want to ever see him again, and I want him in prison as long as possible.
During the hearing, Erin gave a powerful and emotional recount of the night she was attacked. Despite the difficulty of reliving those moments, Erin asked the judge to impose the harshest sentence possible, fearing that Bordolini would harm others if released.
There was a delay in the rape kit coming back.
Advocates supporting Erin highlighted the challenges she faced in her fight for justice. One major obstacle was a statewide backlog of rape kits, which delayed critical evidence in her case.
It may have been hard for me to do, but that's fine. He can't do this to anyone else.
You seem to have a very limited insight about your actions that day. You're in denial about them.
As the court proceedings came to a close, Judge Robert Lewis emphasized Bordolini's lack of remorse and denial of responsibility before handing down a sentence of 7.5 years to life in prison. Renee Skoglund, a South Dakota resident, found herself in serious legal trouble during a trip to Tampa Bay. In March 2023, after having consensual relations outside her marriage, she decided to cover up her actions by making a false claim.
That she had had consensual intercourse with an individual while in Hillsborough County, that she felt guilty about this due to her marital status, and she wanted to get checked for transmitted diseases.
Feeling guilty and wanting a free medical test for sexually transmitted diseases, she called 911 with a fabricated story.
I'm sorry?
I was just
Okay, how long ago did this happen?
maybe like 45 minutes ago.
Renee claimed her car broke down on Interstate 75, where a man approached, covered her head with a towel, and tied her in the back seat of her car.
An unknown male approached her, put a towel over her head, and forced her into the back seat of her car.
He put rope on my hands and my feet.
Her story raised concerns and prompted a police investigation. However, it didn't take long for her lies to fall apart. Police discovered Walmart surveillance footage showing Renee buying the rope she said her attacker had used. Confronted with the evidence, she admitted to making up the story.
I never sentenced anybody for perjury, but it's a good reminder to everybody that perjury is a crime, and all of this stuff that you made up and the resources expended on it could have been used and probably needed to be used by other cases that were real.
In court, the judge expressed frustration over the wasted resources spent on her false report. Renee was sentenced to 2 years of community control and 8 years of probation. She was also ordered to pay over $17,000 to the Hillsborough County Sheriff's Office for the costs of the investigation. The Texas teacher certification scandal, uncovered in October 2024, revealed a widespread scheme in which over 200 unqualified individuals fraudulently obtained teaching credentials. The operation was orchestrated by Vincent Grayson, a basketball coach at Booker T. Washington High School, who charged candidates around $2,500 to have proxies, like Assistant Principal Nicholas Newton, take certification exams on their behalf. Test proctors Tywana Guilford Mason and Darian Wilhite allowed these proxy test takers to bypass detection.
She admitted accepting cash bribes in order to allow another defendant to test for other teachers.
Lastly, Assistant Principal LaShonda Roberts allegedly recruited nearly 100 candidates.
Let's make high-profile allegations before, only to have the case quietly filed away because the evidence isn't there. We've seen nothing compelling here.
The Texas Education Agency, TEA, in collaboration with law enforcement, began investigating after noticing unusual testing patterns, ultimately uncovering fraudulent activity involving hundreds of exams. In October 2024, Grayson, Newton, Mason, Wilhite, and Roberts were indicted on charges of organized criminal activity, each facing 2 felony counts with potential 20-year sentences per count. As of June 2025, legal proceedings are ongoing, and the TEA continues to investigate and suspend implicated teachers. The scandal has affected at least 59 school districts across Texas and raised serious concerns about oversight in the teacher certification process. Exxon Gonzalez Caceres, a 24-year-old man, faced legal repercussions following a dramatic incident at a Medley gas station. On March 10, 2023, Gonzalez Caceres was accused of attempting to steal a semi-truck. During the incident, the truck's owner, who was present at the gas station, spotted the theft in progress. Acting swiftly, the owner, along with others, managed to stop Gonzalez Caceres, forcibly removing him from the vehicle and detaining him until law enforcement arrived.
I guess he stole somebody's car while they were at the gas station.
The confrontation was intense as Gonzalez Caceres reportedly tried to ram other vehicles in an effort to escape. However, the group's intervention prevented any further escalation.
They were able to zip tie his hands and zip tie his knees. Something that where your life is not in immediate danger, don't put yourself in immediate danger.
The charges against Gonzalez Caceres were significant, including battery, grand theft, and possession of a firearm by a convicted felon. At his bond hearing, the judge set a monetary bond and issued strict conditions, including an order for Gonzalez Caceres to stay away from the gas station and the victims involved in the case. While the incident captured significant media attention, details about the final sentencing or resolution of the case remain unavailable. In May 2018, while on duty, Miami police officer Lester Bonenblust assaulted James Nicholson, a 66-year-old registered nurse at Jackson Memorial Hospital. The incident occurred after Bonenblust's niece was denied readmission to the hospital's behavioral health unit, and the former officer assaulted Nicholson after an argument escalated.
Count 1, battery on a person 65 years of age or older, and guilty on 1 count of false imprisonment.
The charges included battery on a person 65 years of age or older and false imprisonment. During the trial, the court heard that the officer, dressed in uniform, arrived at the hospital demanding the admission of a patient. When Nicholson explained that he could not discuss patient details, the officer grabbed him by his jacket and pushed him to the ground, causing significant distress and physical harm.
I was never ever expected to be grabbed from the back and thrown from side to side, to a point where I was yelling at the top of my lungs, help.
Nicholson recounted the event with deep emotion, stating, "What happened to me that day should not happen to anyone, especially a healthcare worker."
I do not know.
Family members of both parties were present, with some brought to tears during the proceedings.
Just would like to say that I'm remorseful for the incident that took place.
The former officer accepted full responsibility for his actions in court. He was fired, got arrested, and sentenced. He was sentenced to 45 days in jail, 3 years of probation, and 100 hours of community service. In November 2022, Tampa Police Chief Mary O'Connor resigned following backlash from a traffic stop incident involving her and her husband. They were pulled over in Pinellas County for driving a golf cart without a license plate, during which O'Connor presented her badge and identified herself as the police chief, suggesting leniency.
I'm the police chief in Tampa.
Oh, how you doing?
I'm doing good.
Okay.
I'm hoping that you'll just let us go tonight.
I don't know if betrayal is the word, but disappointment.
The encounter, caught on body cam, led to an internal affairs investigation that concluded she had violated departmental conduct by misusing her authority. Though she initially defended her actions as concern for officer safety, O'Connor later admitted fault and expressed remorse in her resignation letter, stating she never intended for her actions to overshadow her efforts to build community trust.
I think that she was a good choice, and I provide those second chances. You can never know what decisions individuals are going to make down the road, and clearly she made a very poor decision.
Mayor Jane Castor, who had previously defended O'Connor's appointment despite her 1995 arrest as a rookie officer, accepted the resignation with disappointment, acknowledging the need for accountability.
We will ensure that the community is involved, that city council, that everyone has the ability to meet the candidates as we did before.
Officers know their integrity and ethics, and what happened here is a constant reminder of the professionals and ethics that they have to maintain.
The city then launched a new nationwide search for a police chief, promising transparency and community input in the process. In the interim, Deputy Chief Lee Burkaw stepped in as acting chief, prioritizing ethical leadership and restoring public confidence within the department. In Boise, members of the Add the Words movement stood before a judge to face sentencing for trespassing charges. The group had been arrested during a protest at the state capitol, where they refused to leave while demanding anti-discrimination protections for individuals of all sexual orientations and gender identities.
I did have one arrest prior to this, and that was in 1968, and I was put in jail with a charge of holding hands with a black person.
The protesters, united in their cause, admitted guilt to trespassing as an act of civil disobedience. One defendant reflected on their actions, saying,
"You get to be a certain age, you realize that you don't have that many years left. And I want to make a difference. I want to make Idaho safer for my very brave friends. And I want to stand up and acknowledge what is right."
Because the defendants, by their own admission, have broken the law, and not because they exercised their free speech rights.
During the hearing, the state's attorney argued for probation and brief jail sentences to prevent similar actions in the future. The defense countered, praising the protesters as courageous individuals fighting for civil rights.
These are the finest of our society, in my opinion. They're the people who are making America what it is. It's the finest tradition from the Boston Tea Party to MLK to the State House in Idaho right now. And frankly, I'm proud to be here, and I think we all should be proud that folks are willing to stand up for what's right and push civil rights where they need to go.
I would say in the finest tradition of that civil disobedience, you honor the law by doing what you do and being accountable and accepting the consequences for your actions.
The judge ultimately handed down sentences of 25 hours of community service with a nonprofit organization for each count of trespassing. Additionally, the defendants were required to pay fines and court costs. After the sentencing, several of the protesters expressed agreement with the decision, stating that the punishment was fair and a reflection of their accountability. Their commitment to pushing for change remains unwavering. On a cold morning in February 2024, Adeline Addie Pierce was preparing to board her school bus on Jackson Lake Road in Henry County, Georgia. The school bus had its stop arm extended and flashing red lights activated, signaling drivers to stop. As Addie crossed the road, 25-year-old Kaylee Andre, running late for work, approached the bus. Despite the clear warnings, Andre failed to stop and struck Addie. The girl was airlifted to the hospital, but tragically, she did not survive her injuries. Authorities arrested Andre, charging her with first-degree vehicular homicide homicide, illegal passing of a school bus, and failure to exercise due care. After being released on bond, she remained under strict court-ordered conditions, which included no contact with the victim's family while awaiting trial. During the sentencing hearing, the courtroom heard emotional testimony from Addie's family and saw heartbreaking footage from the bus's dashcam. Prosecutors described how Andre's decision to drive that day directly led to Addie's death. They emphasized that though Andre was not intoxicated or speeding, her failure to stop for the school bus was reckless. The prosecution pushed for a minimum 10-year prison sentence, highlighting the lasting trauma on the family, the bus driver, and the students who witnessed the incident.
And I don't think I can say better than the friends and family who have come up today to speak on behalf of Apple and Pierce, the devastation that this defendant's actions caused that day. For whatever reason, whether it was her windshield being frosted, whether she was not paying attention, I don't know if we'll ever really know, but the fact of the matter is she shouldn't have been on the road. She shouldn't have been driving, and if she had decided to do that, she should have stopped for a giant killer school bus with the flashing lights on this straight lane road. Regarding a cap, Your Honor is correct, the facts using the evidence. I don't think a maximum of a 5-year sentence is appropriate in this case. The legislature didn't think so, and Addie's family didn't think so either. That's why we made our initial offer to try and spare them having to listen to this. I think a minimum of 10 is fair, considering the kids on that school bus, the bus driver who had to watch this little child, her little sisters in the car, her older sisters, the rest of her family and friends who are represented here in court, and I'm sure there are many more who couldn't make it today, that love this child, and now who have to live their lives without her. And so for her mom, her family, her friends, for all of them, I think a minimum of a 10-year sentence is the least that this defendant's actions deserve.
All right, you guys come back up to the podium and Mr. Papadopoulos.
Come on up, Kaylee. Oh, yes, Your Honor. May it please the court. Kaylee Andre has been accused today of some things that she plainly didn't do. Kaylee Andre did not skip her bond hearing. The practice of the courts here is that the defendants are kept in the holding area if a bond can be agreed to. That's what happened in this case. She didn't flee from her hearing. She didn't skip it. Kaylee Andre has wanted nothing more than to apologize for her criminal misconduct for the past 15 months. But she has been under bond conditions which require her to avoid any contact with the victim's family. Kaylee Andre has scrupulously followed her bond conditions. At the time of this tragedy, Kaylee Andre was a 25-year-old woman who respected authority and did as she was told. She was told not to drive drunk, and she did not drive drunk. She was told not to race, and she didn't race. In fact, there's a picture of her car brought to a complete stop, probably 60 or 65 feet after the point of impact. That is not a person racing. That is a person who understood that if you are in an accident, you are required to stop promptly. That is a person who followed the rules. Nothing that we can do here is going to bring Dylann back to life. That is what everyone here wants. That is the precious hope that justice cannot deliver. And that is the tragedy. Kaylee Andre's conduct was criminally stupid. Most crimes require an intent to do the act, an intent to kill the person, an intent to break into a house, an intent to do drugs, an intent to drive after you drank alcohol. In this case, the only criminal intent which exists is the intent to drive a car. That is the only intentionality that has been proven. Now, on top of this, there is negligence. There is recklessness. Absolutely. We do not dispute that. We do not deflect from that. We embrace the truth. But there was no intention here to hurt anyone at all. And that brings us to the crux of this case. As her friend testified, Kaylee was anxious. She was depressed. She was late for work. She was in a rush. This court cannot deter anxiety. This court cannot deter depression. This court cannot deter criminal stupidity. This court can only deter actions that are intentionally performed. And the only criminal intent in this case was the intent to drive a car to work on a cold, dark morning.
Andre chose to plead guilty to first-degree homicide by vehicle and passing a stopped school bus. Her defense admitted she made a terrible mistake, but stressed that she never intended to harm anyone.
Mr. Allen, do you have any questions?
No, Your Honor.
Ms. Forrest, do you have any questions?
No, Your Honor, although I do need to advise the court that she is eligible for her first offender penalty.
That was not a request that was made.
We request first offender treatment.
Did you have a conversation with Ms. Andre about the benefits and burdens of first offender?
I did, Judge, and I explained to her that if she got 15 years on probation, which I expected, there would not be any real downside to asking for it.
And is it your desire to ask for it now?
Yes.
Ms. Andre, you're notified of the following concerning first offender sentence you're requesting. If you as a first offender probationer violate the terms of your probation, the court may enter into an adjudication of guilt and proceed to sentence you to the maximum sentence provided by law. And for you on this case, that's 15 years. Do you understand that, ma'am?
Yes, ma'am.
Additionally, I want you to understand that if an adjudication of guilt is entered, you may be sentenced to a sentence greater or more restrictive than that imposed today. If you violate the probation, you can get a maximum of 15 years. You understand that, ma'am? However, if you are so sentenced, you will receive credit for the time that you've served on probation against any new sentence. And if you successfully complete this sentence, you will not have been convicted of a crime in this case. Ms. Andre, have you ever been convicted of a felony in this state or any other?
No, ma'am.
And do you understand the conditions of first offenders? I'll explain them. And did you discuss the benefits and burdens with Mr. Adams? And do you still wish to be treated as a first offender? Okay? And so I will accept the plea pursuant to OCGA 42-8-60. Anything else, Ms. Forrester?
No, Your Honor.
Mr. Ash?
No, Judge.
All right, Ms. Andre, if you will have a seat for me, the deputies are going to take care of you, and I will take care of the paperwork. Before we adjourn, I would like to say to all of you that this is a tragedy in every sense of the word. And I do want to say to the family that I think you guys have shown remarkable grace and kindness in this matter. You've shown remarkable grace and forgiveness for Ms. Andre, who is obviously someone who did not intend for this to happen, but this is just the nature of these types of charges. I say always that we as people, for all the things that we have done, all the things that we've accomplished in our lives on this planet, we have not been able to come up with a word that sufficiently captures the loss of a child. We have words for everything else. We have words that are redundant, that mean the same thing 3-4 times, but we are unable to come up with one single word that captures the loss of a child to a parent. And so I think the thing that captures what happens here today is the statement from Karen that today is not a measure of your child's worth, and then there's no sentence that I can impose that can give you guys any measure of comfort. But I hope that at least by bringing it to a conclusion that you are able to at least move on from this part and go back to doing the real work of mourning the loss of this child. So thank you for coming in this morning and telling us about this amazing human that you guys had the pleasure of knowing for 8 years. And I hope that you have some measure of peace from the conclusion of this exercise.
And sentenced her to 15 years, with the first 8 years to be served in prison and the remaining 7 on supervised probation. She was also granted first offender status, allowing the felony to be cleared from her record if she successfully completes probation without violations. In the aftermath of the tragedy, Georgia lawmakers passed Addie's Law, which went into effect in July 2024. The new law requires school systems to adjust bus routes so students do not have to cross busy streets, and it significantly increases the penalties for illegally passing a stopped school bus. In August 2024, Cleveland Browns defensive tackle Mike Hall Jr. was arrested in Avon, Ohio, following a domestic dispute involving his fiancée. After the incident, a protection order was issued, prohibiting him from having contact with the victim while the case proceeded. The situation attracted public attention, as Hall had recently been drafted by the Browns earlier that year. As the legal process unfolded, both sides engaged in discussions. By mid-September, a resolution was reached between the prosecution and the defense. The initial domestic violence charge was reduced to a lesser offense of disorderly conduct persisting, a 4th-degree misdemeanor. Before the court accepted the plea deal, the judge made sure that the victim had been informed about the agreement and was comfortable with the outcome. The victim's attorney confirmed that she fully supported the resolution and did not wish to make any statement during the hearing. In court, Hall entered a plea of no contest to the amended charge.
Thank you, Mr. Craig. So, Mr. Hall, if this is what you would like to do today, I'm comfortable, given the representations that's been made to the court, I'm comfortable at this point reducing the charge to the disorderly conduct persisting. But it is a 4th-degree misdemeanor. The maximum penalties for this offense are up to 30 days in jail and up to $250 in fines. Do you feel you understand so far?
Yes, ma'am.
Okay. And you've had an opportunity to speak with Attorney Spellacy about your trial rights that you're giving up today?
Yes.
Okay. The effect of a no contest plea is that although you're not admitting guilt to the charge, you are admitting to the facts of the case. This is an amended charge, so there would be some stipulation to a finding of guilt as well. And essentially, you're agreeing to be found guilty of the amended charge of disorderly conduct persisting. Do you feel like you understand these things?
Yes.
Okay. Understanding. One last question. Have any promises or representations been made to you in order to induce you to enter this plea today?
No, we are.
All right. Understanding all these things, do you still wish to enter a plea of no contest and stipulate to a finding of guilt to a disorderly conduct persisting charge?
Yes, Your Honor.
Okay. I will grant the prosecutor's motion and I'll accept your plea. Mr. Creedy, you wish to?
I would just indicate that once the warrant is issued, the counsel was notified that the defendant did come to the police station to accept some
Thank you, Mr. Craig. Mr. Spellis, do you wish to be heard?
Thank you, Your Honor. Judge, first of all, we're appreciative of the resolution that we were able to reach here. I can tell you that this is an unfortunate incident, but from every incident you can always learn something. I can tell you that Michael has taken steps to better himself regardless of what brought him here. I can tell you, Judge, that he is in some counseling, if I can approach him.
You may.
And 3 different letters, 3 different dates from somebody that he's working with. I think it'd be informative for the court to take a look at those.
Thank
you. Can I ask that those not be made part of the...
Yeah, I agree. I think that they're protected, so they won't be made part of the official record.
Thank you very much, Your Honor. Judge, having said that, we're grateful for the resolution. I can tell you that he's, whatever the court does, we're ready to accept. Thank you.
Thank you. Mr. Attorney Long, is there anything else that you feel the victim wishes to be heard on before I impose a sentence?
No, Your Honor.
The judge accepted the plea and moved forward with sentencing. Hall's attorney spoke on his behalf, explaining that Hall had already taken steps to address the situation by participating in counseling. The court was provided with confidential reports from Hall's counselor, which reflected his efforts to improve himself. Hall also briefly addressed the judge, expressing his regret for the incident and his commitment to personal growth.
Mr. Hall, certainly now's your opportunity if you'd like to say anything before I impose a sentence.
First and foremost, I'll just say I just regret this whole situation, and I wish it just never happened. But just taking those steps and just receiving counseling and just trying to better myself. Thank you.
I think that's reflected here in these letters that your attorney submitted to the court, that you are taking steps in order to improve yourself and improve maybe the relationships of the people that are in your life. And so I'm really glad to see that that's happening.
Yes.
All right, it'll be the sentence of the court that the court will impose a 30-day jail sentence, but the court will suspend all of the jail sentence, meaning you will not serve any jail time, on the condition of 2 years of monitored time of good behavior. If I see you back at the court, it doesn't matter if it's specifically domestic violence, disorderly conduct. If you are charged with any new criminal charges in the next 2 years, that'll be brought to my attention, and the court will have a review hearing, and the court could impose some or all of that suspended jail time. Do you really understand so far?
Yes, sir.
All right. With regards to the fine, it'll be a $250 fine that will be imposed plus the court costs. Anything further, Mr. Spells?
No, Your Honor. Thank you very much.
Mr. Hall, anything else you wanted to address with me today, or any questions you wanted to answer?
No, Your Honor.
The judge sentenced Hall to 30 days in jail, but suspended the entire sentence, meaning Hall would not serve any jail time as long as he complied with the court's conditions. He was placed on monitored supervision for 2 years, with the understanding that any new criminal charges during this period could result in the reinstatement of the suspended jail time. Following the court proceedings, the NFL placed Hall on the commissioner's exempt list, preventing him from participating in team activities, while the league reviewed the matter under its personal conduct policy. After further review, the NFL issued a 5-game suspension without pay, making him eligible to return to play after serving the suspension. In September 2016, Atlanta attorney Tex McIver was riding in the back seat of an SUV driven by a family friend, Danny Joe Carter, while his wife, Dylann McIver, sat in the front passenger seat. As they traveled through the city, McIver asked for his weapon, which Dylann handed to him. Moments later, while the vehicle was in motion, the weapon fired. The bullet struck Dylann. Carter immediately drove to Emory University Hospital, but despite emergency surgery, Dylann did not survive. After Dyann's death, the case quickly drew public attention. Prosecutors argued that McIver intentionally shot his wife due to financial stress and disputes over control of property and business interests. McIver maintained that the shooting was accidental, claiming he fell asleep with the weapon in his lap and it discharged unintentionally. The case went to trial in 2018.
My understanding is that you all have reached a verdict. Juror 20, you're the foreperson? Yes. All right, I need you to stand, please. Was the verdict that was reached a unanimous verdict?
Yes, it was.
And have you or someone on your behalf completed the verdict form, signed it, and dated it?
Yes, sir.
All right, if you could give it to Deputy Murphy so I could see it, please. Thank you. Juror 20, I would like you please to publish the verdict, which means read the verdict into the record.
On count 1, murder, we find the defendant not guilty. On count 2, felony murder, we find the defendant guilty of felony murder. On count 3, aggravated assault, we find the defendant guilty. On count 4, possession of a firearm during the commission of a felony, we find the defendant guilty. On count 5, influencing a witness, we find the defendant guilty.
Thank you, Juror 20. You can take a seat. Deputy Murphy, if you would please give the verdict form to Mr. Rucker and then to Mr. Harvey. Mr. Rucker, do you have any objections, or does the state have any objections to the form of the verdict?
No.
Mr. Hardy?
No, but we'd ask for a poll.
Okay. Ladies and gentlemen, I will be calling you by your juror number. When I call your number, if you would please stand, I'm going to ask each of you the same few questions. And we're going to go numerically. Get this over here. Juror 5. Was the verdict that you heard read in court your verdict back in the jury room?
Yes, it was.
And is that something you have freely and voluntarily entered into?
Yes.
Is it still your verdict?
Yes.
Thank you. Juror 7.
McIver was found guilty of felony murder, aggravated assault, possession of a firearm during the commission of a felony, and influencing a witness. He was acquitted of malice murder, which would have required proof of intent to kill. During his sentencing, McIver gave a lengthy statement where he spoke about various personal topics, including friends, family, ghostly experiences, and even Chick-fil-A. However, notably absent was any direct apology or expression of remorse for Diane's death.
What the jury said in the end was that it was not an accident. The jury concluded that you, Mr. McIver, intentionally pulled the trigger of that firearm, not with the intent to kill your wife and the family matriarch for Corey Enterprises, but that you intentionally pulled the trigger. And they delivered a verdict that supported that conclusion. I do believe, consistent with what Ms. Clark Palmer said, that if you in fact love Diane McIver as much as you've just shared with me, and others have shared with me through the letters and what we heard at trial, then there really isn't a form of punishment that any judge could impose that would be more severe than the burden of knowing that you took Diane McIver from all of us. I didn't know her before the trial. I feel like I know more about her, but it's clear in listening to Mr. Corey and Mr. Grover and Ms. Williams and Ms. Carter and others who testified during the trial that she was family to those people. As we mean that term, not a blood relative, but just as much as a blood relative. And you took Diane McIver from all of them as well. Their loss in many ways is the same. I'll tell you what's most telling. You had as much time as you wanted to share with me what you thought was important for me to hear, and I guess your audience to hear. We heard about racehorses in Australia, and Chick-fil-A, and telepathy, a brief psychoanalysis of the male ego and ghosts. I didn't ever hear you say you're sorry for what you did. To me, that silence speaks volumes. Mr. McIver, the sentencing options are largely determined by the legislature in this case. The penalty for felony murder is life. I'm going to sentence you, count 2, to a term of life with the possibility of parole. Count 3 merges into count 2. Count 4 must run consecutive to count 2. It must be 5 years. I will suspend those 5 years. Count 5 is a range of 1 to 5. Excuse me. I will sentence you to 5 years to serve. That will run concurrently with count 2. The sentence I just intended to pronounce is a sentence of life plus 5 with those 5 years suspended.
The judge pointed out his lack of remorse before sentencing him to life in prison with the possibility of parole, along with additional years for the other charges. Years later, in 2022, the Georgia Supreme Court overturned McIver's murder conviction. The court ruled that jurors should have been given the option to consider involuntary manslaughter as a lesser charge, which could have significantly altered the verdict. Following the reversal, McIver entered a plea deal in January 2024. He pleaded guilty to involuntary manslaughter, reckless conduct, and firearm possession. As part of the agreement, he was sentenced to 8 years, with credit for time served, followed by 7 years of probation, 5 of which would be served under house arrest. During this hearing, McIver finally expressed remorse, saying he would always love Diane and carry deep grief over her loss. In January 2025, McIver was released from Augusta State Medical Prison after serving his time. He now remains under supervised probation with specific restrictions, including home confinement and conditions limiting his contact with certain individuals and his former law firm. Tariana Paschal, a 32-year-old woman from Cleveland, first connected with Todd Morgan, a 41-year-old assistant professor at Cleveland State University, through a dating app. After exchanging messages for several days, they agreed to meet at Morgan's home in Hudson, Ohio. What started as a simple meeting soon turned into a tragedy. In the early hours of April 19, 2023, Paschal arrived at Morgan's residence. Shortly after midnight, Morgan sent $50 to Paschal via a mobile payment app. Not long after, shots were fired inside the house. Later that day, when Morgan failed to pick up his daughter from school, her mother grew concerned and contacted the police. Hudson officers conducted a welfare check and found Morgan's body lying, having suffered shot wounds. Evidence collected at the scene, including shell casings, bloody footprints, and digital records, pointed directly to Paschal's involvement. The investigation progressed quickly. By May 2023, Paschal was arrested in Akron. Detectives used DNA evidence, mobile app records, and location data to place her at the crime scene. Summit County Prosecutor Elliot Kolkovich described the incident as an isolated act, while also acknowledging the deep loss felt by Morgan's family, friends, and colleagues who respected him in both his personal and professional life. Paschal was charged with multiple offenses, including aggravated murder with a firearm specification, aggravated robbery, tampering with evidence, and theft. As the scheduled jury trial approached, she chose to plead guilty to aggravated murder with a specification. During the hearing, Morgan's mother, Sandy Morgan, gave a powerful victim impact statement.
Your Honor, my name is Sandy Morgan, and I am Todd's mother. I'd like, and thank you for the opportunity to let us speak today. I'd like to show the court a couple photos, if I may. This was from Todd's funeral. There's only 5 pictures here, and they're supposed to kind of grasp his life as he was growing, but his life was so much more. This was the Easter before he passed away, when I was at his home with his children. We went to church that day, and he told me, he said, "Mom, I'm broken, and I know only God can fix it, and I want to give my life back to God." That was indeed a special day for a mom who's been praying for him. Anyway, Katie, can you take that? This is Todd and his brother Sean, who he just has no words for his grief. And this is me and my children when they were younger. Todd was about 12 there. And this is when Todd first moved to Ohio, when he was about 18, 19 after high school. That was his first apartment. Thanks. This is a shirt that we all had made and gathered at his cemetery to have a service on the anniversary of his death. I'm not wearing it. I will put it on later, but I had to think about Todd in all of this, and I just thought Todd would want his mom to wear something else. I'd like to address you, Ms. Paschal, in my statement. I'm Todd's mom. I always will be. Todd's not here to tell his story. Only God, Todd, and you know the truth of what happened on April 19. All I know, he was brutally murdered by you, and he basically died for nothing. You didn't even know him. Your actions to take my son's life changed my life forever. It's changed all of our lives. Even more so, you took a father from two beautiful children. They were his world, and he was theirs. On the morning of Monday, April 17, Todd and his children got up for school. They left their toys where they last played, their snacks and drinks in Aaron's bedroom where they played Minecraft. Their Easter bucket still full of candy sat on the living room floor. Their shoes and coats were on the back by the slider. They planned on coming back home to their things, but most of all to their daddy. Todd dropped them off for school. Aaron recalls his daddy's last words to him: "I love you. I'll see you Wednesday. We are going to our favorite restaurant and have our favorite French fries." Because of you, Todd never got the chance to pick up his children ever again. They never got to say goodbye. When Todd did not show up to pick up Cece from school, her mother knew something was wrong because Todd would never not show up. She called 911 for a welfare check. Todd was found lying in a pool of blood just a couple feet from the slider, his handprint on the slider indicating he had tried to get out of the house. He lay there for 12 hours before he was found. 30 hours later, I found myself hearing the words that no one should ever have to hear. Do you have a son, Todd? Yes. Well, I'm sorry to inform you that he is no longer with us. What? He's passed. My brain, to protect my whole being, went into I went numb. I screamed. From that day forward, my life has changed. I'm sad most of the time. I feel like I'm living a nightmare. I want to tell everyone here, and especially Miss Peschel, about Todd. You knew nothing about him, yet you took his life. I loved him dearly. As a child, Todd was fun and energetic and intelligent and strong-willed.
She spoke about her son's accomplishments, his devotion to his family, and the unbearable grief his death had caused the entire family.
Yes, to his family. I'm very sorry, and I hope that one day that you can find it in your hearts to forgive me. That's it.
All right, Ms. Peschel, I will remind you of a couple of things. First and foremost, did you execute the violent offender database form?
She's going to sign it right now, Judge.
All right.
Paschal also addressed Morgan's family briefly, saying she was sorry and hoped they might one day find it in their hearts to forgive her.
Thank you to the family for being here, for Mrs. Peschel's family, for Mr. Morgan's family for being here throughout all these processes. I'm fully aware of how much support Mr. Morgan had in the community, not just professionally, but certainly familially. I think every one of you have been at every court proceeding. It just shows what a important person he was in your life. There's nothing that the court can do to make this better, to make this okay. to make this any easier. I will say that the avoidance of a trial is a benefit to everyone because it is an extremely traumatic experience for everyone involved. And there would be images and things that you would have to see that you could never unsee. And so I appreciate Ms. Paschal for taking responsibility for this and making it so that the family does not have to go through any additional trauma based on the actions that occurred back in April of 2023. Based on the facts and circumstances in consideration of all relevant sentencing factors, applying the minimum sanction the court has determined will protect the public, yet also punish the offender, and not provide any unnecessary burden on state or local resources. A period of incarceration is certainly necessary due to the nature of the offense and the loss that's suffered by all of the victims in this matter. I'm sentencing you to a period of 20 years to life on count 1, aggravated murder and unclassified felony. In addition, that sentence will run consecutive to the 3-year firearm specification, which is attached to that count 1. That firearm specification 3-year sentence must be served first, it must be consecutive, and it is in fact mandatory. This will make you eligible for parole, which there's no guarantee of that, at the earliest at 23 years, but you could serve up to life in prison for this matter. Do you understand all of that, Ms. Paschal?
Yes, Your Honor.
All right. I will reiterate that the parties did reach this joint recommendation, and it was provided to the court prior to the acceptance of the plea, and it was, I would say, poured over by many of the people involved. So I am following that for all of those reasons. Did I forget anything on behalf of the state?
No, Your Honor, thank you.
On behalf of the defense?
No, Your Honor, thank you.
All right. At this time, I'm going to execute the violent offender database form, and we will file that and have it made part of the record. Thank you, everyone.
After considering the seriousness of the crime, the loss suffered by the victims, and the sentencing guidelines, the judge sentenced Paschal to 20 years to life for aggravated murder, plus a mandatory consecutive 3-year term for the firearm specification. This made Paschal eligible for parole after 23 years, though parole is not guaranteed. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.